Welcome back to the Friday 5 for October 18th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. And on Fridays, we like to take about 5 minutes and look at 5 questions from the week, some from new clients, some from prospective clients, some from former clients. Maybe these are questions you've had in the past as well, and you're interested what the answers are. So let's get started. Question 1 this week, should I put all my rental properties in one LLC? So in this case, the caller actually had about 8 or 9 different rental properties and was trying to figure out what's the best method to use for liability protection. And they'd done some reading online, and their thought was, let's just put all of the properties into an LLC. And the analogy I make is that this is similar to that old saying of don't put all of your eggs into one basket. So if we put all of our properties into one LLC, and there's a lawsuit on one property, then the other properties are also considered an asset of the LLC and would be subject to a judgment against that one property. So the way I always like to explain it is, an LLC is better than no LLC, but the next step up, the better step, is to have an LLC for each property, because then we're able to contain that liability to that property in that LLC. If you have a bunch of properties, like in this case they have 9 different properties, and you can't afford to set up 9 separate LLCs, another option you can do is group some of them together, so maybe 2 or 3 properties to an LLC. This is not a perfect way to do it, and you're still then exposing other properties to liability, but it's better than not having any LLC at all. So generally, should you put all of your properties into one LLC? Probably not. What I more often see people doing is putting each property into an LLC and then having a holding company LLC that owns the individual properties underneath it. So in that case, it would make sense to have that one LLC that can own all of your sub-properties. But before you go down that road, that's one of those discussions you want to have with your accountant to make sure that by doing that method, you can actually take advantage of it from a tax standpoint. Question 2 this week, does an indemnification clause need to be mutual? So I was reviewing a contract with a client, and there's an indemnification clause that the other party was indemnifying my client for anything that happened, but there was no mutual indemnification, meaning my client would not have to indemnify the other party under this contract. And to take a step back, indemnification says that if something goes wrong under the contract, you are essentially saying that I agree to defend the other party. So in the case of this contract, the other party was saying that if something happened due to them that was attributable to my client, as long as it wasn't gross negligence or my client didn't do something terribly wrong, then the other party would actually be responsible to defend and indemnify them. They would be the ones to take care of any lawsuits or take care of any damages. So these are very powerful clauses in contracts that you need to understand how they work, and it's important to understand which way they flow. So normally you'll see either a mutual indemnification, meaning that you're each indemnifying the other, and that's then to protect the other party in case you do something that's not proper under the contract, the other party doesn't want to get sued. It's a little less common that we see a contract like this where the other party proposes a contract where they're saying we will indemnify you, but they're not actually seeking you to indemnify them. So the clause does not need to be mutual, but in most cases it will be. Question 3, what happens if mediation doesn't resolve our dispute? So in this case, we have a couple of family members fighting over a business, and they're trying to figure out the ownership and going forward. They have an operating agreement, which is a good first step, but unfortunately they can't figure out the best way to wind down the business or have one buy the other out. So what they've done is they've gone to mediation, and they did a few different sessions with the mediator. Mediator was very helpful, was able to really flesh out a lot of the issues between the parties, but they just couldn't come to a final agreement. And so the question from my client is, what do we do next? And if you've have an operating agreement that says you go to mediation first, and after that mediation, if it doesn't work, then the next step is normally going to be a lawsuit. It's going to make things a lot more complicated and a lot more expensive, and maybe the parties will be able to work out a settlement instead of a lawsuit. But just because your mediation doesn't end up in a settlement agreement doesn't mean that you don't have any options and you're just stuck with your family member. In this case, the next step would be a lawsuit. Question 4 this week, how much money should I leave to charity in my will? And this is really a personal decision for you, and what kind of charitable giving you want to set up in your will and how much you would like to leave. And the real question was, how do we want to do it? So one way to do it is what we call a specific bequest, a specific gift, where we say, off the top of my will, I'm giving $5,000 to my local church. The other way you can do it is if you have a spouse and you have children, but if they all predecease you and you're the last one living, and then you have no relatives left, you can then give a percentage of whatever's left, including 100% to charity. Now, the downside to that second method is that, of course, if your wife is alive and you have children alive or grandchildren, then that charitable gift will not ever happen because somebody else is there to inherit. So if you really want to make sure you're leaving something to a charity in your will, we want to move that up to the front, do a specific bequest, and say, I'm giving to the church X dollars or percentage of my estate, whatever it is that you want to give them. But you want to do a specific bequest if you want to make sure that something is left for them. And then question 5 this week, what happens if a family member doesn't agree to what's in a will? Sadly, this can happen, especially if you have different bequests, or you have different, what you're leaving for your family can be different levels, like one child gets 10%, the other two get the 90% split 45 each. The child who got 10% is going to feel left out, going to be angry, going to be hurt, and hopefully there's a reason why you're doing that kind of distribution. But in that case, if that child who only got 10% doesn't agree to what's in the will, they can actually file to contest the will in probate court. Now, what you need to be careful of, especially if you're the person who's considering contesting it, is if the will has a contest clause. Usually the contest clause will say that if somebody challenges the will, we treat them as if they've deceased me, so that you don't receive anything if you then try to challenge the will in court. So you have the right to challenge, but you need to understand that if that contest clause is there, you may actually end up with nothing in the end if the contest clause is upheld by the court. So that's generally what happens if a family member doesn't agree with what's in a will. The other option is you can try to work out some agreement with your siblings. Maybe they agree that mom was being a little harsh, and they say you can have 30% and each of us will take 35%. So you can always work that out amongst family members after the fact. But if you're challenging a will and there's no agreement, you're going to have to go to court and have a court decide what should happen with the estate. So those are our questions for the week. If you like this video, you can hit the like or thumbs up button below. You can subscribe to future episodes on YouTube. You can submit a questions for future episodes in the link below. And you can always go to my website, 𝙃𝙀𝙊𝙇𝙊𝙒.com, for a legal strategy session or for more information. Wherever you are, I hope you have a wonderful weekend.